Your Honor, my name is Randall, R-A-N-D-A-L-L, initial G, and I appear for the defendant, Katie and Louise Enterprises, trading as Young Chic line of retail stores. I'm instructed by Spółka Prawnicza Prawda Solicitors. On February 15, 2015, Katie and Louise Enterprises entered into a contract with Blink Enterprises, Hong Kong-based company. The business was reproducing jewelry accessories made by a Fifth Avenue Tiffany store in Manhattan. The jewelry was to be supplied to the Australian market prior to Tiffany's release of the products in Australia. The reproduction jewelry was to have the intention to be faithful in every detail in accordance with the original product specified. The order included the use of cheaper metal alloy and silver plating. The contract was for a total of $30,000 value of the goods and was to be delivered in 3 batches to Australia. The contract was of a commercial nature between the companies. No issue here. The authority to rely here is Edwards versus Skyways. The offer was accepted by Blink Enterprises. The parties gave consideration to the contract. Blink Enterprises to produce and deliver jewelry to Australia, and Katie and Louise to pay for the product and delivery. The contract stipulated that Queensland law was applicable to any dispute between the parties. The contract also included the provision that Australian consumer law guarantees as to quality and fitness of jewelry be struck out between the parties. Australian consumer law has guarantees as to acceptable quality, guarantees as to fitness for a particular purpose, and guarantees not to be excluded, for example, by contract. The law expressly gives guarantees for fitness and quality of the products and cannot be struck out of the contract. The contract with Blink Enterprises, removing the provision from Australian statutes, therefore is deemed to be void within Australia and cannot be enforced by the court. Customer complaints have been lodged about the product quality relating to the first batch of goods. Contracts that are contrary to the statutes in Australia are considered void and cannot be enforced by the law. The first batch was delivered and paid for on time. No issue here. The contract was executed. The second batch was delayed by the wharf strike in Brisbane and therefore could not be delivered on time. Neither party was at fault for the late delivery. It would stand to reason that nobody could predict the wharf could go on strike to prevent the delivery of goods on time at the time of contract formation. The law states that the contract becomes void from the moment the frustrating event and the losses and gains lie when they fall. In this case, both parties would have to absorb the losses in relation to the frustrating event and lack of delivery. The third batch was additionally not delivered on time due to transportation arrangements by the factory located in China. Blink Enterprises had the responsibility to assure the timely delivery. The third batch delivery delays would constitute a fundamental breach of the contract. The timely delivery was a crucial and essential condition of the contract. Without it, the business accrues losses as Tiffany rolled their product to the stores on the Australian market, and the goods had to compete with the product. Katie and Louise Enterprises may have standing to terminate the contract without paying for the goods. In conclusion, I would like to apply for the contract to be declared void, as the goods produced by Blink Enterprises were of poor quality, and with this being said, the contract was contrary to the law of Queensland and is deemed void. The goods were not delivered on time as agreed in a contract. The delays with the second batch delivery should be considered to be a frustrating event. The delivery of third batch of goods was a fundamental breach of the contract condition and should allow for the contract to be terminated. Your Honor, I respectfully ask to consider all the facts that they have been presented to you. My client appeals to you that the case is looked upon equitably and just. My client acknowledges that the removal of clauses from the Australian Consumer Law statutes was contrary to the Australian law. The breach of the contract by the Blink Enterprises with delivery and frustrating event cost my client already unrecoverable losses to the business. Unless I may assist Your Honor further, those are my submissions.